Hi, Brendan Lupetin from Myers, Evans, Lupetin, and Unitin. And I just wanted to briefly talk about claims for negligent infliction of emotional distress in Pennsylvania, because we hear a lot about them and they are a very different animal of a claim that certain types of people can make under certain circumstances. So, before we get into what the actual claim is, we have to talk about negligence in general. So typically with negligence, to prove a negligence claim, so somebody hits you with their vehicle or does something else careless that physically injures you, you have to show that there was negligence, that somebody wasn't careful, that the negligence caused actual harm to you, which is typically some type of a physical impact to your body, something that happens to your body that causes injury, and then you have to show and explain the extent of damages that were caused by the injury as a result of the negligence. Negligent infliction of emotional distress claims are different because typically what they have to do with is that the person that was injured emotionally, mental distress, anxiety, depression, PTSD type symptoms as a result of being present for or seeing something terrible happen that was caused by someone else's negligence, but there was no significant physical impact. So there are basically three ways that you can make out and substantiate a claim for negligent infliction of emotional distress. All three always begin with a negligent act by the defendant. So you have to prove that they did something negligent. But where it gets tricky is where the cause of the harm comes in. So first, there are what are called impact cases, which are basically your typical type of negligence claim, except the impact is very, very minor. So one example was, and the cases that support this are very bizarre, but a person was driving down the road and there was a dead body laying in the middle of the road at night. They had no idea what it was. They hit it and afterwards came to realize that they had hit a dead body and suffered a great deal of emotional distress at the idea of that having happened to them. And they wound up suing another driver who had hit this person and killed them and left them in the road and driven off. Now, they brought a negligent infliction of emotional distress claim under the idea that the other person's negligence, the driver who drove away, did something negligent and then later on caused them to experience something that had caused them a great deal of emotional distress, anxiety, etc. And the court in that case, when we're talking about this trauma component, the impact component, said that the mere jostling of the person in the vehicle, so getting shaken about in the vehicle when they hit the body in the road, was enough to substantiate an impact. There have been other cases where they've said something as minimal as a needle stick was sufficient to have a causal connection between a negligent act and the emotional distress injuries. And there are other instances where somebody was caused to breathe in a noxious odor or feel something that caused them to move and in turn suffer injury. So it could be that minor. But the first category is impact, that there's some minor impact from the negligence that is then connected to emotional distress. Where it starts to get tricky is the second component, the second way you can prove a negligent infliction of emotional distress claim, and those are called in Pennsylvania the zone of danger type cases. Now, these are situations where the plaintiff, the person who says that they were injured as a result of emotional distress, was in a very close proximity to the sort of mechanism of force that could have caused them great injury, but did not actually make contact with them, but was in such a close proximity and it occurred in such a way that the plaintiff feared legitimately for their safety or their life as a result of this force that was very close to them and was caused by the negligence of somebody else. So here's an example where you can imagine a person is on a sidewalk, standing there minding their own business, and because of somebody else's negligence, there's a car collision, and a car comes careening by and misses that person by, inches or feet, and they legitimately feared for their life. It was an incredibly close call. That's a situation where the person can bring a negligent infliction of emotional distress. But the key there is essentially that they were within what is called the zone of danger. And the zone of danger is subjective under the circumstances. So in one instance, it might be how close were you to, for instance, the careening car. Another would be potentially there's a downed power line, and the force field on the ground is known to be as far as 30 feet wide, and the person was at 15 feet when they realized that there was a downed power line and got out of the way quickly. They didn't suffer any impact, they didn't suffer any physical harm, but the fear of believing that they may or were about to experience that harm is sufficient to connect the emotional distress, anxiety, PTSD type things that they develop afterwards. The third category for negligent infliction of emotional distress is called the bystander theory. So this is a situation, imagine that same idea where the negligent car collision caused the car to go careening across. But this time imagine that the plaintiff is standing on one side of a highway and watches the vehicle go careening off and hit a family member and injure or kill them. So in that situation, the plaintiff, the person that is saying, I was emotionally distressed, I was caused mental anguish as a result of what I saw, is well far away that they were not in the zone of danger, but they saw something happen to a close family member. And so it's that last part that almost in exchange for the close proximity to the zone of danger, if you witness it, but you're far away, you're outside of the zone of danger, but it's a close family member, it has to be a family member, then you can make a claim for negligent infliction of emotional distress in Pennsylvania. But keep in mind on that last one, it has to be a very close family member. It cannot be a friend. It can't be a fiance, at least that the case law talks about. It has to be an actual family member. And the person making the claim has to firsthand see it. There are cases saying that if the person comes to the scene after their family member's been injured or badly or killed or something terrible has happened and then sees it at that point, that is not sufficient to make that connection between the two. So in sum, in Pennsylvania, there are three ways to make out a negligent infliction of emotional distress claim. One, they're showing that there was some type of minor impact that connects the negligent act to the injury and the emotional harm. Two, you've got the zone of danger. So it was the close call type case where the person truly believed, because of the close proximity to the dangerous mechanism, that they were almost injured or almost killed. And then finally, there's the bystander, where it's a family member some distance away who firsthand observes a negligent act injure another family member. If you don't fit your claim into one of those three categories, then you cannot bring a claim for a negligent infliction of emotional distress. I hope that was helpful. If you have any other questions, feel free to email us or call us at Myers, Evans, Lupitan, and Uniton, 412-281-4100. Thank you.